When someone passes away, the legal side of things is rarely the part families want to deal with. Yet it's often the part that causes the most tension. One of the most common questions we hear at Blackstone Solicitors is whether someone should challenge a will or bring an Inheritance Act claim. They sound similar, but they're actually very different routes, and choosing the right one can make all the difference. Let's break it down in a way that actually makes sense. Picture a family where the eldest son discovers he's been left out of his mother's will entirely. He's convinced something isn't right, because she'd always said her estate would be split equally. In that situation, he might be looking at challenging the will itself. That means questioning whether the will is valid. Perhaps his mother didn't have the mental capacity when she signed it. Perhaps someone pressured her. Perhaps the will wasn't executed properly. Challenging a will is about saying, this document shouldn't stand as it is. Now take a different scenario. A woman has lived with her partner for 20 years. They weren't married, but they shared a home, bills, and a life. When he dies, she discovers he never updated his will, and everything has gone to his estranged brother. The will might be perfectly valid, but it leaves her in a financially vulnerable position. In that case, she wouldn't challenge the will. Instead, she'd bring an Inheritance Act claim. That's where the court steps in to decide whether she should receive reasonable financial provision, even though the will didn't include her. So the key difference is this. Challenging a will is about whether the will itself is legally sound. An Inheritance Act claim accepts the will as valid, but argues that the outcome is unfair to someone who should have been provided for. Another way to think about it is that challenging a will looks backwards at how the will was made, while an Inheritance Act claim looks forwards at what the person left behind, and whether it meets the needs of those who depended on them. Both routes can be emotionally charged. Families often feel torn between wanting to honor someone's wishes and wanting to protect themselves from an unjust situation. And the truth is, these cases are rarely straightforward. We've seen wills written decades before someone's death that no longer reflect their relationships. We've seen people cut out of wills after sudden fallouts. We've seen partners and children left struggling because the law didn't automatically recognize their role in someone's life. If you're unsure which route applies to your situation, that's where proper legal advice becomes essential. At Blackstone Solicitors, we help people understand their options and take the right steps with confidence and clarity. Thanks for watching. If you found this helpful, feel free to like and subscribe. And if you're facing a will dispute, or wondering whether you have a claim, get in touch with us at Blackstone Solicitors. We're here to guide you through it.